argument, and I expect we'll probably take a break after the third case, a short break. We begin with United States v. Williams. Mr. Wisely.
May it please the Court, I'm Vincent Wisely, and I'm here on behalf of the appellant Howard Williams. The government distinguishes this case on one fundamental basis. That is, they distinguish this case from other cases that apply the rigors of Federal Rule of Evidence 702 to cell phone data extraction technology, or testimony that involves that type of technology, particularly cell-bright technology. And that fundamental basis is that it requires no specialized knowledge or a technical understanding of the internal mechanics of the extraction process on the part of the witness, and therefore no sponsoring expert is required.
So what have the other circuits done on this, Mr. Wisely?
I'm sorry, I didn't.
What have the other circuits done, the other federal circuits, what have they done?
Yes, Your Honor, I do recognize that the appellant does not have many cases to draw upon where the facts were the same or the conclusions drawn by the court were to apply Rule 702. However, there is one common denominator across many of those cases, if not all of them, and that is that the subject matter that is being testified to should come from the officer's personal knowledge and observations, and that if the wealth of that officer's experience bears upon those observations, then that will cross the realm into Rule 7.
So you say it's context specific. There's no bright line rule.
Yes, Your Honor, I do.
And you filed the motion in limine.
Yes, Your Honor.
And was that carried with the case?
Yes, it was carried with the case.
So your objection is to the trial court's ruling when, I take it, you object to Detective Rush?
Yes, Your Honor.
But you were given an opportunity to voir dire Rush.
I did. I was given that opportunity.
Okay, so what then would you quote once he takes the stand? What answer of his would you quote to say most displays that this was specialized knowledge as opposed to firsthand lay opinion?
Well, specifically from his testimony on page 597, lines 3 through 5, he does not only say that he gathers information from this type, or that he gathers this type of forensic evidence. He says explicitly that he investigates it. So as a cell-bright operator, he has training and he has certifications.
So he enhanced his credential.
Yes.
He just said the background is I investigate. Is that the strongest example of?
No.
So what's the strongest testimonial example of improper expert opinion evidence or lay evidence coming in, I guess, that you'd say, and yet the answer actually rests on specialized knowledge?
I believe that it rests upon the fact that this particular witness, as many witnesses in these types of cases, have this training and certification. If it was as simple as turning on and off a machine, connecting that machine to a device and pushing a button and waiting, no technical certifications or training would be required of officers whose function it is to gather and investigate this type of evidence. So when the government touts the training and experience, the certifications of the particular witness in front of the jury, it creates a circumstance whereby the witness, although not being qualified as an expert, enjoys the perception by the jury of being an expert. It then blurs the line between lay testimony and expert testimony. It is essentially expert testimony in lay witness clothing. So I believe that's the strongest distinction, Your Honor.
Let me make sure I understand how this was presented to the jury. So all this information is taken off the phones, and this particular witness had looked at it. Was any of this displayed to the jury? Was there a big monitor in the courtroom that displayed what pages looked like or anything like that?
Yes, Your Honor, and that is...
So it seems to me on the expertise angle, are you arguing that expertise was needed to explain that what was there was actually what had been on the phone and wasn't distorted in the removal process? There were some pictures involved, that was the actual picture. Where is the need to link the process to the, it seems to me, and correct me if you think otherwise, to the reliability of what the jury was being told and shown?
Dates and times were very crucial in this case, as they are in all cases, and it's dates and times that are specifically and often corrupted by malware, security vulnerabilities, data integrity issues. And in this particular case, the claim related to dates and times that could have been corrupted.
Well, you did raise, were you trial counsel?
I'm sorry?
Were you trial counsel?
Yes, Your Honor.
So you did raise at trial, as part of your objection, this malware possibility. The government argues, at least a concern I would have, is that you didn't have much to go on, other than you had some report that malware could affect this. Is that a fair characterization?
It is a fair characterization, Your Honor, because this was only a recent claim.
So it seems to me without more, there's not much the judge had to rely on that how malware could have affected what otherwise, I imagine, looked like accurate sort of information showing dates and transmissions and whatever.
When I reasserted the objection during trial, Your Honor, it was after it was established by the witness, Officer Rush himself, that he stipulated to these issues, this claim, this malware security vulnerability claim. He stipulated to that in the presence of the jury, but then he quickly qualified that it was only applicable to iPhones. And I believe that's where the circumstance was created, whereby the jury perceived his testimony as expert testimony and then dismissed all possibility that this corruption, that this claim of malware security vulnerability was even applicable to this case.
I think I'm still a little same line of questioning. Are you saying that the abuse of discretion here was that the jury heard what in fact was specialized knowledge? Or are you saying that the impropriety here is that the government proffered Rush as an expert without qualifying him? In other words, is there expert opinion that came in improperly, or is it that the government bolstered a lay witness to be an expert?
Both, Your Honor. I believe that the government bolstered the lay witness without really the anticipation that the lay witness would answer the way he did to my questions regarding the malware security vulnerabilities. And when he did...
When you crossed, you didn't ask any questions about reliability, did you? Or can you point to one? In other words, you had full opportunity in voir dire, but then, as I remember, you get up to cross-examine him, and I didn't see much going into specialized knowledge.
I did not have many questions for him with regard to the specifics on this particular claim, because again, as I said, these were recent claims. I was hoping that the witness would have more information and more dialogue concerning the subject matter. But I believe that once the witness recognized that he was crossing the line, then I believe that's where he backed off and he started to claim that it was only his function to gather the evidence, not to interpret it. But typically in these cases, Your Honor, what happens is what the government does is that the government will introduce this evidence in total as a complete report through one witness who is typically a member of the same investigating team, but then they will interpret that particular evidence through another witness. And so therefore they, I guess, avoid the...
But that's what I'm asking you. Can you quote from me any government witness who interpreted evidence that a lay juror wouldn't normally comprehend? You know, that's why we require 702 for fingerprint evidence.
No.
For example, is there a sentence from any witness that was interpretive beyond the knowledge of a juror?
There, other than, Your Honor, the fundamental aspects of those particular text messages, the dates and the times, of course, the phone numbers and you know, the data of that nature. But there is nothing that I can draw upon at this moment where a witness or there was a dialogue as to the reliability of the evidence that the witness was interpreting.
Now, you didn't file a reply brief. That's your prerogative, but that means the answers the government has given, we don't yet know your response. So, of course, one answer they've given is all of this is irrelevant because the victim testified herself and there were other text messages implicating her client. Do you want to now respond to sort of the harmlessness argument?
Your Honor, I do recognize there were other pieces of evidence in this case that were significant, but I believe that with respect to this evidence, this was the majority of the evidence. This was what most of the trial concerned and most of the evidence was related to, or testimony was related to. And so I believe that it's important that this issue be settled because I believe that as I know that the government dismisses the Worley opinion out of the Seventh Circuit, but I think it stands for the proposition. I think the proposition is what we draw upon, and that is that the witness needs to have more than just an understanding of one or two isolated concepts. They have to know how technology works with other technology to preserve information, to maintain its integrity, this type of thing. And I think that it's important that this issue be settled because, again, we stand the chance of blurring the line between lay testimony and expert testimony when it's not that onus of a burden to qualify a witness as an expert. He had the credentials. There was only one more step that would have been necessary, and that was to have asked the judge to qualify him and to enter a finding. But they didn't do that. I don't know why they didn't do that, but they didn't. I don't believe that the witness or that the judge would have denied the witness the status of an expert, as has happened in other cases, but they chose not to, and I believe that was problematic. That's the most problematic part of this case.
The whole extraction was given to you as discovery, so it's not like that Sixth Circuit Grenier case, correct? It's not that something was withheld and then the government said, oh, we didn't give it to you because this isn't an expert. Here you had it all discovery-wise.
I did, Your Honor. I had it all.
Thank you.
So, the government relies heavily also upon the case of United States versus Chavez-Lopez. I think that was probably the case that was most talked about in the briefing. And that's out of the Fourth Circuit, and they use this to support the fact that Cellbrite technology specifically does not require specialized knowledge. But in the government's brief itself, it recognized three distinguishing features of that case that not only distinguishes it from other cases that are seemingly favorable to the appellant, but from this case. And that is, one, again, a common denominator across all of these cases is that this information that the witness is testifying about should come from personal knowledge, personal observation. And in this case, it came from training and experience. There's no denying the fact that that wealth of experience bore upon his observations. Second, that, I guess, based on that, the officer's testimony was not, as this court has previously stated, a product of reasoning that is familiar to the average person in everyday life. I believe that's the way that it was stated, or that's the way the standard has been articulated. So because of this training and experience, it was not information, or it was not the product of reasoning in everyday life. I mean, I wouldn't know that this particular cell phone needed to have 2 extractions run. In this case, the defendant's phone was a phone that the officer stated was manufactured in a manner that would affect the functionality of the Cellbrite software. The victim's phone only required 1 extraction. The defendant's phone required 2. And of course, nobody in that courtroom, and I don't believe anybody in this courtroom would know why or what one extraction or how one extraction was different from the other. So I believe that it's important.
So there were three points of distinction. That's 2.
Yes, that's 2. The third point of distinction is the fact that in the Chavez-Lopez case, the witness in that case didn't make any statement regarding the reliability or effectiveness of the software. And in this case, as I've stated already, the testimony by the witness in front of the jury that this possible reliability issue applied only to iPhones was a clear statement. It was implicit. I would argue it was explicit, but either way, explicit or implicit, it was a validation of the integrity of the data. So I believe that those 3 distinctions, which were in the government's brief, is what distinguishes Chavez-Lopez from this case. And I think those distinctions are inherent and prevalent in all cases that we look at that the government has cited. And the case, here in the Fifth Circuit, the United States versus Rubio case that the government cited, that was not completely instructive to us. The court reiterated its past treatment of the Cellbrite technology, but that was a confrontation clause issue. And I think the question there was whether or not the statements that were extracted from the defendant's phone that were authored by a co-conspirator were testimonial in nature, and the court ruled that they were not. But this, I believe, is a matter of first impression, at least with the facts that we have in this case, Your Honor. And so I would ask, Your Honor, that you hold that this that the Rule 702 does apply in this case and should have applied during trial. Thank you.
Thank you, Mr. Wisely. You've saved time for rebuttal. Thank you, Ms. Pryor. Mr. Wisely for rebuttal.
Thank you, Your Honor. The government states that this was a basic cell phone extraction, and of course the appellant would disagree, primarily because of the fact that we have the training and experience element in this case, and we have the statement by the officer who, I believe, enjoyed the perception as an expert by the jury of the reliability of the extracted data. The Gainier case, as the government mentioned and distinguished, I believe is important because it states as a proposition that when construing this rule, if the officer's testimony in any way draws from scientific, technical, or special knowledge, it is covered, and it should come under Rule 702. She also mentioned the Julius case, or I'm sorry, the Worley case, and has distinguished that here in court as well as in her brief. But again, the Worley case stands for the proposition that if the officer's wealth of experience or if his training and education bears upon his personal knowledge or observations, that is expert testimony. I believe that is or should be the bright line rule. It will avoid us in court from blurring the distinction between lay testimony and expert testimony.
We would be creating a circuit split, is that right? Would we be creating a circuit split?
Yes, Your Honor, we would be. As the court faced in the Julius case, which was after, in which the Seventh Circuit reconsidered its treatment of this issue in the Worley case. In the Julius cases, that case was a basic extraction. That was a basic extraction of a cell phone. Of course, that case went up to the circuit court on plain error review. And so the circuit court, although they asked plenty of questions during oral argument concerning the issue, and they did fear that this would create a circuit split in this, by their decision, they avoided the question, or they did not have to reach the question, I should say. And they stated it specifically that they would leave the broader implications of Worley for another day. Well, the broader implications of Worley is whether or not 702 should apply across all devices, not just a hard drive, but also a cell phone. Because in the Worley case, there was a footnote that said that cell phones were not included in their analysis.
But all devices, I mean, isn't Cellbrite evidence closer to a copying machine, right? It's just printing out what's already there. It's not interpreting, say, fingerprint evidence. Do you disagree?
No, Your Honor, that's correct. It's not interpreting fingerprint evidence. That certainly would require...
Or polygraph or medical tests. So you wouldn't say a device that's a photocopier if the agent is just going to say, well, I photocopied this.
No, and I also would not say that it's a photocopy or mirror image of the cell phone. I would not say that either. I believe that if that was the case, then Cellbrite wouldn't have to use a complicated software to read the information and to interpret it. So the software is interpreting a lot of this information and putting it out in readable form.
Rush testified, and after I ran the extraction, I confirmed that each image was an image that I can presently see on the phone. It's an identical mirror. He didn't say that?
He did, but he was only talking about some of the images related to some of the advertisements. He wasn't talking about the entire extraction report. That the extraction report, every page of it, the thousands of pages that were produced, were an exact mirror image of the phone. That's not what he was saying. He was saying that the photos that the software spit out, that those photos were the same as the photos that were contained in the defendant's phone. But when we go so far as to say that this is a mirror image.
But those photos, just to test you a little, those are the photos that incriminated your client. In other words, it's not a plain view type case where the government found something else that's complex or distorted. It is the mirror image photos that they used to incriminate.
Those photos were photos that were contained on the defendant's phone. However, the issue with those photos, it was not clear cut. I mean, the dates and times were crucial on those photos because there were photos taken by the victim even before she met my client.
Yeah. Okay.
Yeah, so there, again, the corruption and the malware vulnerabilities could have affected the dates and times on those photos. And again, the government says that, oh, I'm sorry. Thank you.
All right, thank you, Mr. Wisely. And we noticed that you're court appointed. We wish to thank you for your willingness to take the appointment and for your good work on behalf of your client.
Thank you, Your Honor. It was my pleasure.
All right, United States versus